Great. Oh, okay. Hello, everyone. Okay, this is the problem with this room. Everyone just kind of sits in the edges, and then poor Nico is going to have to like stand like this. If you can move in a little bit, then that would be really great. So, as to give Nico as much time as possible, I'm going to hopefully not squeeze in my chair, but hello. Hello, everyone.
As slow as you want. As slow as you want.
My name is Grace Menning. I know many of you. I'm the Executive Director of the Espiritu Program on Public Interest Law and Policy. It's truly an honor to be here today to introduce our lead fellow, Nico, Espiritu. We are able to invite Nico here this week to be in residence at UCLA Law through the generosity of Margaret Levy, who is here today. The Levy Fellowship is a cornerstone of our Public Interest Program. It exemplifies what we are trying to do as we educate, train, and support the next generation of visionary public interest leaders. When we invite someone to be a Levy Fellow, we think about who is playing a leading role in issues of national importance. As an academic institution, we seek to create a space where the fellow, students, and faculty can think deep and hard about issues that may get a lot of airtime, but are not being thought through with care and nuance. At the same time, the Levy Fellowship offers meaningful opportunities for students to learn from the fellow how to be a public interest leader. Built into the fellowship is a conversation on the fellow's career path that is open only to students, that's tomorrow, and the opportunity for students to sign up for one-on-one office hours. And I love this about the fellowship. This is, to me, so wonderful and unique that this idea of mentorship is embedded in this fellowship. This year, in Nico's grade 2, we have truly the Levy Fellow of Levy Fellows. When I asked our colleagues at the Center for Immigration Law and Policy who they would recommend for the Levy Fellowship, Nico was at the top of their list. He is an outstanding attorney and leader, the Deputy Legal Director of the National Immigration Law Center, one of the foremost national organizations fighting for immigrants' rights in this critical moment. It's hard to pinpoint like one thing they've been doing, but I will say they filed just 2 days ago a lawsuit challenging the Trump administration's registration requirement for non-citizens. Nico is an innovator of NIL's Education for All campaign, which seeks to protect access to K-12 education, regardless of immigration status, an issue that is very live right now. Before joining NIL, he was an attorney with MALDA, where he focused on voting rights. In addition to being an incredible litigator, Nico is also a scholar who has been a fellow at the Carr Center for Human Rights at the Harvard Kennedy School. His most recent piece is on education and democracy from Brown to Harvard. Nico is also a dedicated mentor and teacher who has taught voting rights in the Immigration Policy Clinic here at UCLA. Wow. He loves meeting with students so much. When he broke his hand right before his planned visit in March, he initially said he would still just get on a plane 12 days after surgery. We insisted that he not do this, and we're so happy that he is here with us today. Thank you so much for being here.
Thank you so much, Grace, and thank you to the entire PILT staff for putting this together. I have had the opportunity to participate in a number of PILT events, as well as attend so many, and I think you provide an essential resource not only to building the next generation of public interest lawyers, but also as a mechanism to sustain the students while they're here in times good and bad, and in times as challenging as this one. So I really thank you guys again for all your work. And thank you so much, Maggie Levy, for creating this opportunity. I think I would have really benefited from having the ability to have practitioners and scholars come in while I was in law school to talk about their trajectory, to learn from their successes and their mistakes. We had the opportunity here at UCLA to have professors that could do that, to bring their lived experiences in. And those few opportunities were some of the most important times that I had to learn how to be a lawyer, and how to be hopefully a kind one. So thank you again for this opportunity to be here and to get a chance to share a little bit about what I've learned in my career. It's a difficult time right now. That's that's not saying very much. To talk about like how to do a public interest career in the face of everything that we are experiencing as a country, speaking for myself, as people of color, and for many other communities which are marginalized and devalued at this moment. It's an incredibly challenging time. I'm not going to hide that fact. I mean, where could we start? We could talk about the fact that we're seeing students being disappeared for expressing political opinions. We could talk about the systematic dismantling of protections from healthcare systems, environmental protections, or any number of institutions which are meant to protect the most vulnerable amongst us. We could talk about the devaluing of people based on their gender identity or any other characteristics which is not deemed to be acceptable by one portion of the society. We could talk about the erosion of democratic institutions from attempts to make it harder for people to vote, to the elimination of access to justice. We could talk about how many of the institutions on which we've relied upon are now capitulating to the current administration's ideological agenda. And in the immigration situation, we could talk about people being returned to countries with terrible human rights abuses and humanitarian conditions. We could talk about the litigation that we just filed, which seeks to block up a public universal registration system for immigrants. We could talk about the elimination of our ability to speak about and analyze the history of this country to the extent that it disagrees with the narrative of forward progress. These waves and waves of crisis keep crashing over us. How are we supposed to understand this moment? So for me, I have long relied upon, I've looked to similar times in history to see how they suggested that we address these moments. And one really influential piece of this history was really brought to light by a German Jewish thinker by the name of Walter Benjamin, who spent the last part of his life while fleeing Vichy France, Nazi-occupied France, writing 20 fragmentary paragraphs on how to live during a moment in history where fascism was coming down and closing upon Europe, and ultimately on himself as a person. These theses on the philosophy of history are really a work that offers a solution, or offers a suggestion on what can be done in the face of these fascist politics that are promising to grind so many of us into the dust and institute a totalizing regime where even the dead will not be safe. That's his words. For Benjamin, this moment wasn't a blip on a path towards progress. What he was really suggesting was rather that we understand that this state of emergency that he was facing was not the exception, it was the rule. And he asked us to then take a different look at history, one that didn't accept this idea of universal progress, but instead asked us to brush this history, as he said, against the grain, to pick out those moments where there were crystallizations of time, where we could see resistance, where there were victories that were had, and there were successes that were built. Not just for material gains, but he said we could look at these moments as ways to find the courage and cunning so that we could seize the moments in the now time that we have to resist the forces that we're facing. I think that his admonition about like how we treat history is also how we should treat our own lawyering. So much of what we are asked to do in the training that we get as lawyers is to take the received wisdom as though the law has worked itself pure in some way, and that this is what we have to deal with. Whether that's our idea of substantive due process that we're currently facing, whether it's the idea of the really diminished concept of equal protection that we're facing, and just keep running forward with it. We don't often have the time to think through times in which there has been a pushback against these currents, in which despite the forces that are being aligned against us, advocates, lawyers, and communities have worked together to push back against those particular moments. So I'm suggesting that we take Benjamin's suggestion into our legal practice. And to do so, I think requires us to look for how, in similar times, we have faced challenges like these, where communities are targeted, where politics are lined up against us, but nonetheless there has been resistance, and resistance that has continued to create both the material and community organizing principles that allow us to keep moving forward. For me, when I think about the immigrants' rights community, the fight over education has long been one of those struggles, where there has been time and time again an effort to reduce the protections, but nonetheless there have been moments, despite defeats, despite roadblocks, that advocates have figured out ways to build upon the community work that has been done in the past, to move forward and to build the potential for communities to keep empowering themselves. So, over 40 years ago, the Supreme Court in Plyler v. Doe issued what I think is one of the most important equal protection decisions that has issued in this time. There, it said that it is unconstitutional under the Equal Protection Clause for a state to discriminate in allocation of a free public education, even when it comes to immigration status. One of the things that it said in this decision was that to do so would eliminate the ability of these students to eventually become full participants in our society. Now we can take that in a number of different directions, but the thing that is most important to me about that, when I think about full participation in society, is the skills that are necessary to engage robustly in the democratic process. That is, to speak with others, to organize, and to figure out creatively how to use levers of power to protect your communities. It's not just to fit into the existing society, it's to figure out how to become agents who can change that society. And that is the thing about education that I think is so important to protect. Many of us have not come from very nurturing education institutions, but we also have to understand that they are really the lifeline that enables people to get the information necessary, to have that access, whether it's directly or 1 or 2 degrees, to understand that things don't have to be the way they are today. So Plyler, by protecting access to K-12 education, kept that path open. This was, as I said, a really monumental victory in terms of our constitutional jurisprudence, to recognize that we should not just accede to a government's assertion about why it wants to discriminate against students. Let's take a harder look at that process. Let's really look at the reasons why the government is claiming that it's going to engage in this differential treatment, and then subject it to more than just the minimal level of scrutiny for something so important as education. As I mentioned, Plyler was decided over 40 years ago. That means the kids that were in high school then, who were Plyler students, many of them are not just Plyler high school graduates, some were college graduates, many are parents, some are grandparents. We're talking about, during those 40 years, the fact that hundreds of thousands, if not millions of individuals have had the continuing ability to get an education and progress their lives forward. We would think that this was an amazing public good. Earlier today, someone was talking with me and mentioned the fact that we transitioned away from the idea of education as a public good, and talking about how, that's a real problem. And I think that we need to reclaim that, to understand that education must be understood as the kind of public good that allows individuals to flourish in that way. But it hasn't been. The truth is that since that 40 years ago, Plyler has been under attack. Really the first coming as early as the 1990s, when here in California, there was a statewide initiative passed called, it was called the Save Our State Initiative, also commonly known as Proposition 187. It would have broadly denied almost every state social service to people who are not in this country legally. One of those denials would have been the denial of K-12 education. So as early as 10 years after the passage, after the decision in Plyler, we're already seeing a concerted effort to put measures on a ballot which will then result in this case being brought back before the Supreme Court. This is a playbook we've seen in a number of other places, including attacks on reproductive rights in recent years. It was once again, at that moment, it was already understood to be an attack on the Latino community. Unfortunately, this kind of xenophobic and anti-immigrant rhetoric was carrying the day in California at that point. Community members quickly banded together, and litigation was brought challenging Proposition 187. And that litigation was successful. It's a complicated procedural history as to why ultimately it was successful. But one thing to take away was that the courts were used in that moment to delay the implementation of Proposition 187. There was good case law as to why these provisions should have been struck down. But then, as is now, there was always been a fear that courts can be recaptured by individuals on the right. So litigation was not the only tool that was used at that point in order to try to block the law. What happened in the short years afterwards was an effort to organize voters in California to change the politics in the state. And after the governor, Pete Wilson, was then turned out, Democratic Governor Ray Davis was elected into office. Ray Davis then, with his new administration, ended the litigation by coming to an agreement with the litigators. So it wasn't just litigators in court that figured out how to solve this problem. It was community members who organized in a way so as to have their communities actually be represented rather than being targeted. And California's politics are different to this day. We are not risking the state passing laws that would undermine Plyler rights at this point. Instead, what we have at this current legislative moment are legislators who are pushing pro-immigrant legislation and additional protection for immigrant students. So we see that the courts were a stopgap measure that allowed us the space to do the kind of organizing to get real political change. But so we see that Plyler's rights were protected in that moment, but this wasn't the only space where there was an attack on the educational rights of undocumented students. I mentioned time passes. Plyler K-12 students, many wanted to go to college, including here in California. Unfortunately, there was a law on the books at that time which made undocumented students not qualify to be residents for purposes of in-state tuition.
groups of educators banded together with lawyers to figure out creative legal strategies to try to get these laws struck down by the courts. There were some initial victories by a group that came to be known as the Leticia A, that was the named plaintiff, network at that point. And so the Leticia A network then not only mounted legal challenges to the denial of in-state tuition to undocumented college students, but also began to create resources for teachers and students to figure out how to navigate the challenges that they were facing. So litigation is working hand in hand with community movements who are looking to effectuate the rights of students. This issue bounced back and forth in the courts for a while, and you know, in a sad moment in UCLA's history, an individual who worked here mounted another legal challenge to these victories. I'm not going to mention his name. He doesn't actually need any more, you know. Let's let some things in history kind of disappear. But unfortunately, it meant that in the mid-90s, college education was practically out of reach for undocumented students here in California. This is the moment that I kind of enter into my political awakening. So I was just graduating high school during the time of the passage of Proposition 187, and I began working with students in the communities that I grew up with who were hoping to go to college and were now facing the barriers that these decisions, these court decisions had created that had denied undocumented students functionally the ability to go to college. So at that moment, I decided to go to law school to try to figure out how to address these. During the time I was in law school, this same political momentum that we saw that began to see more Latino elected officials being brought into office also meant that some of these new Latino officials, including an individual named Mark Fireball. Did I get that right, Tony? Yeah. Yeah. Sorry, I know Tony knows his history really well. Put together a piece of legislation which would creatively reverse this problem and allow most undocumented students who had grown up here in California the ability to pay in-state tuition. This bill, known as AB 540, then passed while I was in law school. It was spearheaded by Plyler students who had been able to continue to protect their right, who had been able to go to college because of Plyler. Go to high school because of Plyler. These same individuals were now advocating for their ability to go to college. They were going to Sacramento. They were working with legal organizations to advocate for their rights. They were telling their stories about what it meant to be able to continue their education. And a mere, a little over 5 years after the passage of California's Proposition 187, about 6-7 years later, we are at a place where California is now extending educational rights for undocumented students to go to college. Now, this is almost immediately challenged, this new law. So an organization, Federation for American Immigration Reform, and their legal arm, and a lawyer by the name of Chris Kobach, who is now the AG of the state of Kansas, brought a lawsuit challenging this new law, AB 540. At this moment, I had graduated law school. One of the first things that I did at that point was then working for an organization called the Lawyers Committee for Civil Rights of San Francisco Bay Area, was begin to go out to college campuses throughout the state of California to talk with undocumented students were beginning to form groups, student groups on campus that were attempting to address the issues facing undocumented students who are growing in numbers on these campuses. Questions about access to basic resources, how to navigate systems, and then ultimately any pushback that these campuses might have had towards the access that they would have. I went to UC Davis, I went to UCLA, went to UC Berkeley, met with students, talked with them, and worked with them to convince them to join in defense of AB 540, to join this lawsuit. And so here's where we start to run into like, well, what is it that an impact lawyer does, right? What do? We argue what legal arguments are best serve our interest. We work with the tools at our disposal. At this point, we're arguing about a tricky area of preemption law. Has the federal government circumscribed the state's ability to do this under federal immigration law? And so this is the legal issue at play. The legal issue before the courts is who has the power to determine the rights of undocumented students? Is it the federal government? Is it the state governments? Not exactly like it's not motivating for folks. But it doesn't have to be. But to leave it at that place, that it's just an argument in courts, would be incredibly disempowering. How does that build power for students? How does that build power for these communities? So you have to approach the work differently. So instead of just going there and getting signatures for lawsuits, we held town halls throughout the state as the litigation was going, where we explained to them supremacy clause, preemption principles, what was being argued, so that they could understand the court process and what was happening. At the same time, we were talking to them about what else would be necessary in order to further the goals of these students. How could we push the boundaries? What else could we implement if we want? What were their needs? Such as, school is still incredibly expensive, even if you pay in-state tuition. These students wanted to get tuition assistance as part of this. We're like, oh, wait a second, we need to win this legal fight, but that's what they were telling us that they needed. And so we then went back and we helped students learn how to, once again, lobby Sacramento to address these issues. We kept them informed about what the progress of the litigation is without letting it subsume their other goals. And so in this way, students were learning not only kind of the basics they need to build their careers, but also learning how to continue to be their own best advocates, and also learning an important lesson from us, which was that as lawyers, we don't have all the solutions, and to be able to push back, and how to be empowered clients that we were working with, and that we were ultimately really working for. And so I think that part of this process was educating this newly politicized immigrant community on how to become their best advocates. So amazing, we think that this is amazing times. We're getting students through college. We're saying, okay, we're going to keep working towards something. I know that at the end of the day, this doesn't solve all the problems, but we can keep working towards finding solutions for things. So 2001, 2002, 2003, these years keep going. Students keep graduating. And so there becomes an argument that are happening between public interest advocates, national organizations, and the students about how to continue this advocacy. National organizations were saying, no, just have some kind of form of comprehensive immigration bill that pushes its way through Congress. We can't do piecemeal legislation. The students, at the same time, were being like, well, what do you want us to do? We're graduating high school, we're graduating college. We can't work, we have no work authorization. We're still subject to deportation. We want to try to move forward something that helps our community right now. So there was this huge debate between national organizations and on-the-ground activists about what to do. And eventually, there was a break, in part, I think, because these same students had realized they don't have to just listen to the quote-unquote holders of knowledge who tell them what to do. They can become their own agents. And first, there was an attempt to push through what is commonly known as the DREAM Act, which would have offered a path to status for many of these same kind of FLYRA students, 85 World students and the like. Unfortunately, that didn't pass, and we're still in the place where we are today, where there is still not a path to permanent status for most of these individuals. But that didn't stop these same students from trying to figure out other avenues to try to find some kind of solution to keep their progress moving forward. So after 2010, when one of the versions of the DREAM Act was once again rejected, students got together these now students and students who have graduated, got together to try to figure out the next steps forward. And they decided that they were going to try to push the Obama administration to take executive action to address these issues. Those organizing efforts that happened here in Los Angeles, that many of them happened at the UCLA Labor Center, who I know many of you have come to visit at. Some happened back east. They came up with an idea to ask the Obama administration for prosecutorial discretion in the form of deferred action. This was a strategy that was developed not only in terms of saying we're going to ask the executive for something, but forcing lawyers to give advice that they would then evaluate so that they could go make their ask to the administration. That was done, many of you have taken classes with Hiroshi. Hiroshi wrote the letter that became kind of a legal basis for asking for prosecutorial discretion, building on the work of other scholars and building on the decision of these students about how to go about their own advocacy. And it was through very, very clever advocacy, including, at the time, the students were like, well, if you're not going to meet with us, maybe we'll meet with this young senator from Florida, Marco Rubio, who was at that time had expressed some inclinations to do something positive on behalf of immigrant communities. Maybe we'll go ask him to introduce some legislation to help us, which would have been a win for the for Republicans and potentially undermining support for Obama during the 2012 presidential election. So they were thinking about real power politics at that point and political strategy. And it was suggesting that they might go do these things, along with engaging advocates, engaging scholars, and then being the ones that went to DC to advocate on their own behalf, led to the announcement 30 years after the announcement of the FLYRA decision to the day for the Deferred Action for Childhood Arrivals program doctrine. That program has allowed, once again, over 1 million individuals, and currently about 500,000 individuals, to be able to continue building lives here in the United States, including through, being able to work, provide for their families, continue educations, and do all the things that allow struggles to continue despite overwhelming odds against them in terms of the political climate and finding permanent solutions. So this is kind of the broad history of how the education really lays the foundation and is an organizing tool for enabling people to get the skills and ability to advocate through the various mechanisms of our democratic governance, to advocate for themselves. It forces politicians to be accountable. It forces communities to be accountable, and it forces us as lawyers to be accountable. If we give students the ability to advocate in these various mechanisms. And that takes us to our current moment. So right now, once again, we're facing a real threat to Plyler. We knew for some time that Plyler would continue to be a target of the right and of anti-immigrant groups. They had written scholarly articles about this. They had brought, various kind of like incursions into the rights that undocumented students had. They had tried to put in document collection requirements as an attempt to chill access to public education. We had successfully fought these both in the courts and in terms of legislative actions for some time. But the reality is that as we saw with reproductive rights, at the end of the day, many of these groups, like the Heritage Foundations, figure that they can count to at least 5 on the Supreme Court for issues. Meaning, they think that if they can just get these issues teed up, they can eventually win at the end of the day. What does this mean for us as impact litigators, whose jobs and bread and butter has been to go before the courts, mount legal arguments, try to use them as a mechanism to protect rights? It just means that it's not sufficient anymore, and that we need to go back to what we have done in the past when we're looking to protect the rights of vulnerable communities. And I think this history that we have seen from Plyler, from Proposition 187, from AB 540, and DACA really demonstrates that we need a real interdisciplinary solution to address this problem. It's not enough to just have some law passed in some random state and then for us to go sue it. We need to put the infrastructure together to empower communities to be advocates, to continue to use this core idea about the importance of education and change the narrative about why it's so that we can emphasize why it's important, not just for U.S. citizens, but for everybody. And to do that means that we are going to have to get ahead of an effort to make this a zero-sum game, and the idea that only certain folks should be included in education. So that involves things like engaging in narrative change, figuring out what works, what messages work to reach voters who might not necessarily be our friends on a number of issues. It means building political power in various places, in states which don't traditionally or have not traditionally had empowered immigrant communities. So we're seeing in places like Oklahoma, in Tennessee, in Idaho, new suggestions being put forward to the legislature to undermine private rights. Those infrastructures aren't in place like they are in California, like they are even in places like Texas, to allow immigrant communities to figure out how to effectively lobby legislators to show out at legislative hearings, to make their voices heard and build coalitions that allow them to push back. Finally, I think that it requires us to have that kind of creative thinking as litigators about how to approach these issues. It means working not only with community groups to figure out what their ultimate goals are, but also figure out if we can leverage arguments that we might not have always been comfortable with. So for example, treating states as state constitutional provisions as something that we're going to rely on now state law something that we can potentially rely on rather than just federal constitutional law, shifting our focus from necessarily just equal protection doctrine or these more vulnerable legal doctrines and trying to incorporate additional arguments that might win the day. And that's not to say that this will ultimately protect Flagler, but I think what we have to do in this moment is really to figure out how to empower communities to stand up for their rights now, and then even with momentary setbacks, to figure out how to build moving forward. And so one of the things that we're doing is currently, we're doing all the work out there in terms of going to places, like I said, like Oklahoma, like Tennessee. We're building the network of legal advocates to sue. But we're also trying to figure out what it would look like for us to implement laws on a state and local level which would actively protect students. And so we're going out there, we're doing surveys of existing state laws. And we're hoping to build the kind of coalition around these issues that enable us, when the moment comes in some places, to put additional protections in place on a state and local level. So we need to be flexible in this way in terms of our advocacy strategies to figure out how we can keep this process moving forward so we can allow for the kind of institutions in place to allow the next generation of advocates to once again come to the forefront. And so I'll just maybe pause there and then say that I think this moment that we're in, where education is coming under attack, where is for a reason. The efforts to deny undocumented students access to education are part and parcel with an effort to deny an inclusive education. They're part and parcel with the idea of a privatized education system. All of these things taken together are being done because education does provide this ability for us to get the skills to become active democratic citizens. It does provide us the opportunity to build the skills to change the social relationships in this country to one that we think are more just. And so I think that it's imperative now more than ever to make those strong linkages between the need for education for all within the idea of an inclusive critical education that continues to allow us to build this kind of framework, that it will be necessary for us to move past this current moment that we're in. So thank you so much, and I'm happy to answer any questions.
Yeah, I'd love to hear a little bit more about the suit that you just filed and
The registration suit, or?
Yeah.
Now I gotta switch gears. So okay, so folks may have seen that as part of implementing Trump's executive orders, there has been Department of Homeland Security and others they issued what's called an IFR, an interim final rule, that mandates that all non-citizens register with the federal government. And they did so pursuant to World War II era law, which doesn't include a registration provision. It's been very rarely used. It was used during World War II. It's also kind of controversially used during special registration in like 9/11. But since World War II was really the last time there was a universal registration system put in place. What the IFR would do was both create criminal penalties for failure to register, but also create criminal penalties for failure to carry registration documents. This law, we really understand that this is part and parcel with the ramping up of an enforcement and deportation mechanism, which is going to target immigrant communities and subject them to incredible amounts of terror. So our organization, along with a number of other alliances, including the Immigration Council, who's leading this litigation, filed a lawsuit challenging this new regulation, largely on APA grounds, as the primary argument, saying, well, you didn't work with notice and comment, you did this as like an emergency interim final rule, and it is otherwise arbitrary and capricious. And we filed that Monday, and in DC District Court, we are currently looking to be arguing this as a summary judgment, in summary judgment posture as early as April 8th. Look, it's a difficult lawsuit, but the idea that it makes any kind of sense for the federal government to just drop with almost no notice this new criminal provisions upon immigrant communities is really only designed to do one thing, and that's terrorize these communities. And so we think it's important to get into court and try to block this rule from going into effect. We're going to continue to fight this. Registration provisions, the universal registration provisions targeting vulnerable and demonized communities have been a shameful part of so many totalitarian and fascist regimes. And it's no surprise to me that this was something that they are trying to utilize as part of a mechanism of mass deportations. And so we think we're right on the law in this lawsuit, and we think it should be blocked by the courts. But it's one of a, I talked about this at the top of the talk, like so many things are happening all at once. Like how do we as a community grasp this at the same time? Temporary protected status is being stripped away. Humanitarian parole is being stripped away. There's attempts to grant to grant new powers to the branches of the military to engage in policing inside of the United States. There's rumors of this. Where court orders are being ignored that prohibit the federal government from engaging in some immigration procedures. It's an overwhelming amount of actions being taken by this federal government at this moment. And I think for us, we saw a real opportunity to step up and address an issue as one of many that are being put before the immigrant rights community and immigrant communities. They're all at the level of critical and of emergency situations that we need to step up and try to address. But I'm very happy that we were able to get this lawsuit on file, and we do have high hopes that it will be successful.
Do you know yet what judge it's been assigned to?
I do, but I don't remember it off the top of my head. So
it's someone that
it is a Trump appointed judge.
that was going to be my next one.
Who apparently has been reasonable on some issues, including Title 42. The Title 42 issues for the same judge. This is what I remember in terms of, we just wanted to assign it yesterday. I was a little busy yesterday, so I forget the name of the judge off the top of my head.
Great talk.
Thank you so
And
much.
I applaud you for your efforts. My question is, what level of coordination exists across the country among organizations such as yours? In other words, how do we create the critical mass for resistance that can push back against this administration that is moving at speeds that, frankly, we've not seen before?
So, I mean, organizing is, so I mentioned this earlier, like, there's like parts of, like, we learn certain skills in law school, and some of us come in with other skills. I learned in law school how to be a litigator. I did not learn how to be an organizer. And one of the things that I think that is important for lawyers who don't have those skills to do is don't pretend that, like, just because you have some other set of skills, those are the only ones that are important. You got to listen to the other sectors to really try to figure out where you bring the right tools to bear. So, Grace mentioned that I am the innovator of the Education for All campaign. So it's a campaign that tries to bring those things together, that brings together different sectors, brings together bilingual educators, brings together lawyers, brings together immigrant rights communities so that there can be a coordinated effort. That's not necessarily the skills that I bring to bear, but it could be the most important parts of that. So we brought in folks to the campaign who have those skills, who can then make sure that those meetings keep running, that we're bringing the necessary people into the fold, and those people are leading the campaign. Those people have, honed their skills in a number of different ways, running different campaigns. Some may be lawyers by training, but others are not. And so, like, it's figuring out how to decenter, in some ways, litigation is the only tool, and figuring out how to incorporate it with a whole bunch of other ones. Now, as a practical matter, how do we do that? How do we, like, build up that infrastructure? So, it takes time, and it takes effort, and it takes investment to do. And each of those things runs into their own hurdle. You run into a time hurdle because there's a million crises. So, like, how do you actually think about something that's happening in the future when you're facing a crisis now? And so, when we were like, hey, the sky's gonna fall around Plyler, we talked to a lot of different organizations out there who are like, yeah, maybe, but, like, we got this other thing that's happening right now. Like, and we need to prioritize that. It takes infrastructure. There aren't necessarily a ton of good models for this. There's a reason why and I think there's plenty of critiques of it, like the marriage equality efforts, like, they had an infrastructure in place that like, there's a lot of criticisms about, like, how that went out, we got left out of those discussions and the like, but they had an infrastructure in place. That takes a lot of work to do, and so we're not necessarily organized along those ways until it's kind of like interdisciplinary infrastructure. And then finally, resources. Both the kind of, like, whether it's philanthropy or just, the kind of the challenges we face in terms of getting resources for a lot of public interest work. Oftentimes you might be facing either an uphill battle because of other crises, or because those institutions are sometimes not listening to what community members actually want and need. And so trying to get those voices heard early so that we can put all these pieces together, I think are real challenges that we face. I feel really happy that my organization was, once the writing was on the wall, and we had, like, one or two statements from politicians saying, hey, let's go back after Plyler, we were able to start putting the little pieces in place and making it essential that we continue to put this program together. We had people that believed in it, took a little pot of money, did one thing, produced one piece of work and said, hey, look, this can be useful to a bunch of people. And then we would get people to, like, start joining meetings with us because we're like, hey, we have a messaging guy, we have these other things which might be helpful. And then from there, we were able to develop kind of a campaign infrastructure which begins to bring in broader sectors. to be part of this conversation, and allows us to do things like, for example, when we were dealing with an attack on plywood in Oklahoma, we were already talking to people in Texas who had been addressing similar issues. And so we got them together in the same Zoom room, because no one meets in person anymore, in order to do strategy sessions about how to go about trying to move legislators or what who needs to be brought into the fold. But that's just one issue. That's not the issues across the board. That is not thinking about how to incorporate this particular issue with other threats on education, and so that's going to take more organized work. And so I think that there's a model here that we can look to, but I think this work is slow. It's not spectacular in the same way that and I use spectacular in the sense of the spectacle that is created in the American psyche with all these executive orders and coming out of Trump's administration. But I think the work is essential. And as we face this onslaught of things, we need to remember that this slow behind the scenes work can be done, needs to be done, and we need to remain focused on that process so that we can continue to build power for the moments in which we have an opportunity to really push back against this.
Well, I feel like that was a super inspiring end. Anything else you want to say, Nico?
Thank you all for coming. I really appreciate it. I'm very happy to be here in community with you all. And I really look forward to you all joining me in whatever form you do as members of the public interest legal community, in whether you are government lawyers, whether you're in public interest organizations, whether you're in private firms, the ones that are still stand up to what's happening. And thank you so much.